Hello and good morning, everyone. Thank you for joining us for our July installment of our First Friday webinar series. We're going to give folks a couple seconds here to get logged in, and then we will get started. All right, well, we're going to go ahead and get started here this morning. Again, thank you for joining us for our July's First Friday webinar series. Our theme for this particular installment is freedom and flexibility, managing employee leave and accommodation requests. As employee requests for leave and flexible work arrangements and workplace accommodations continue to increase, employers are needing to navigate a complex web of obligations under the FMLA, the ADA, Pregnant Workers Fairness Act, and other employment laws as well. In our webinar today, we're going to explore some recent developments, emerging trends, and practical challenges facing employers, including issues such as mental health accommodations, pregnancy-related requests, intermittent leave, and remote work considerations. My name is Tara Paulson, and I am joined by my colleague, Julie Schumacher, and we are going to be your presenters for today's webinar. If you have tuned into webinars of ours in the past, you know that before we dive into the substance of the monthly webinar, we love to bring you just updates that occurred within the past month so that you can keep informed on the ever-changing legal landscape as it relates to workplace law. The first one that we want to go over is really just an interesting article on OSHA and OSHA's stance on surging crowds and workplace concerns in light of the World Cup. So we obviously don't have any of the soccer games being performed here in Nebraska, but we thought that it was an interesting note to bring to your attention as it relates to OSHA's stance. OSHA has a general duty clause that mandates that employers keep their workplace, quote, free from recognized hazards that are causing or likely to cause death or serious physical harm. And there's been a couple of things put out by OSHA that obligation, that general duty clause, does not diminish just because there's an international soccer tournament that's generating massive foot traffic that perhaps could be outside a number of employers' doors. So OSHA doesn't have any standard or regulations for crowd control risks, but it has long recognized that large crowds in close proximity to workers pose foreseeable dangers, and certain businesses could run afoul of this general duty clause if they've not taken steps. Other times we've seen this come into play where OSHA has had to perhaps initiate a violation due to the general duty clause, and crowds are like Black Friday sales events and other things. But again, just because we've got the World Cup going on, again, doesn't impact us as Nebraska employers, but maybe we can just be lucky, I guess, that we are not in one of those cities that could be facing very significant crowds outside their workplaces, and those organizations would have had to come up with some sort of crowd control measures to the extent that it may impact employees. All right, Julie, take us to something that may be more pertinent to our Nebraska employers.
Sure. Our next update comes from the U.S. Department of Justice. In June, they officially took the position that disparate impact liability should be significantly limited in employment discrimination cases under Title VII. So, disparate impact and disparate treatment are two different legal theories of discrimination under the employment laws, such as Title VII. and Age Discrimination Acts. The key difference is whether the claim is based on intentional discrimination or the effects of a neutral policy. So, disparate treatment claims involve intentional discrimination. It focuses on the employer's motive or intent, and the employee must generally show that they were treated based on a protected characteristic differently. Disparate impact, on the other hand, involves a neutral policy or practice that disproportionately affects a protected group. It focuses on the results of the policy, not necessarily the intent of the employer. In these types of cases, the employee generally must show that a specific policy causes a statistically significant adverse impact on a protected group. So, the most recent development in this area came from a June 2026 opinion from the Department of Justice. This opinion concludes that the EEOC's longstanding interpretation of Title VII disparate impact liability is unconstitutional and inconsistent with the statute. The DOJ argued in its letter that liability should generally require proof of intentional discrimination, like the typical disparate treatment claims do, rather than relying solely on statistically unequal outcomes. Specifically, in this opinion letter, the DOJ stated that employment practices should not be considered unlawful solely because they produce different outcomes for different protected groups. The EEOC's historical approach to disparate impact, in the DOJ's view, pressures employers to make race-conscious decisions to avoid liability, which the DOJ contends raises constitutional concerns. This position that the DOJ recently took is consistent with broader actions by the current administration, including an April 2025 executive order directing federal agencies to reduce reliance on disparate impact theories where permitted. It's also consistent with DOJ rulemaking late last year that removed disparate impact regulations from Title VII of the Civil Rights Act, which govern discrimination by recipients of federal financial assistance. So, what does this mean for employers? The DOJ's opinion represents a change in the federal government's enforcement posture, but it does not itself change the law. So, several important points remain true. Title VII still contains statutory disparate impact provisions that were added by Congress in the Civil Rights Act of 1991. The Supreme Court of the U.S. has recognized disparate impact claims under Title VII, and Congress has later codified that framework. So until Congress amends the statute or the Supreme Court changes its interpretation, private plaintiffs may still bring disparate impact claims under Title VII, and courts still remain bound by existing precedent. So practical takeaways for HR professionals and employers. This opinion is a federal enforcement priority. It enforces the current EEOC's leadership and how they have decided that they want to focus enforcement on intentional discrimination. However, employers should not assume that disparate impact liability has completely disappeared. The existing Title VII statutory provisions and judicial precedent continue to govern private litigation unless and until that is changed by Congress or the courts.
Thanks, Julie. Another update we want to share with you all is that earlier in June, I believe it was on June 4th, the EEOC released its new national enforcement plan that outlines the agency's enforcement priorities and areas of focus for investigations and litigation. This plan now replaces the most recent plan, which was actually approved back in 2023. So this new plan is where the EEOC is centering its attention and energies for purposes of lawsuits and investigations. That particular plan identifies as a priority, quote, matters involving intentional discrimination arising from challenging broad-based employment policies, programs, or practices that result in intentional discrimination against employees or applicants for employment. And in doing so, the EEOC is going to include increased scrutiny on policies, programs, or practices that employers have labeled or frame as diversity, equity, and inclusion initiatives. So the plan gives some examples that may receive some enforcement attention, including things like hiring and promotion practices, internship or fellowship programs, diversity hiring panels, diversity statements, race or sex-based employment goals, and other employment decisions that take race or sex into account. So we have covered that on some previous webinars, but if you're an organization that in the past has implemented a robust diversity, equity, and inclusion program that may take different forms, just be knowledgeable that that is an area that the EEOC is going to be looking at with increased scrutiny. As Julie had mentioned in the past highlight regarding the DOJ opinion, the EEOC has stated that it will eliminate the use of disparate impact liability theories in their investigations to the maximum degree possible and will not commence, develop, or continue litigation advancing disparate impact claims. Now, that may seem as a major win or a win for employers, but the shift doesn't really remove discrimination risk for employers. It just changes where the agency looks. So employers, in light of this new plan, should expect closer attention to your decision-making records. Who made the ultimate employment decision? What criteria was used, what other information was considered, whether exceptions have been made in the past, and what the documents said. The plan also identifies some additional priority areas that we want to call to your attention. The EEOC says that they are going to focus on religious accommodation issues following the U.S. Supreme Court decision in Groff versus DeJoy. They're going to have an increased awareness and initiatives focused on application of the Supreme Court's 2020 Bostock versus Clayton County decision, including workplace facilities and religious accommodation. They're going to have an increased emphasis on protection of American workers from anti-American national origin discrimination. They're going to have an increased focus on protection of vulnerable workers, including low-wage workers and individuals with limited literacy or education, and are going to continue to focus on systemic harassment issues. So again, just want to bring this to your attention. Obviously, it is our hope for all of you that you never find yourself having to defend a lawsuit against the EEOC. And so being knowledgeable about what their newest plan is going to target and how they're going to be handling investigations and decisions for potential litigation, we thought was important to make sure that you're aware of. Julie, I'll maybe let you cover the Department of Labor opinion letters, and then I'll go through the very final update that we have, but I'll let you go first.
Sure. So the Department of Labor issued 4 opinion letters in the last couple weeks. They were on hiatus for a bit of time, but they have taken up these opinion letters again. And so they covered 4 wage and hour issues. And so the 4 issues that these letters addressed, the first one involved a question around the compensability of meal breaks. The second one was focused on pre-shift and post-shift activities, when those were compensable. The next question dealt with an employee who worked part of the work week in an exempt role and part of the work week in a non-exempt role. And the last one was a question about bonus pools. So we plan to do a webinar next month on some kind of hot button wage and hour issues, where we'll go into this in more depth, but I'll briefly tell you kind of what the issues were in these opinion letters and what the Department of Labor stated. So with respect to meal breaks, this opinion letter concerned a meal break question with an employer who had a large facility with controlled access points and parking located a considerable distance from the work areas. The question in this that this letter addressed was whether the fact that these employees they were given 30-minute unpaid meal breaks, but if they wanted to leave the premises, they had to walk so far away to their cars to get through the controlled access points that it would take well over 30 minutes for them to have any kind of lunch off the premises. And so the question was whether the setup of this facility potentially made part of that meal break time compensable. So what the opinion letter stated was that the fact that an employee is required to eat his or her meal on the employer's premises or is minimally restricted in the activities that they may perform does not convert this time period into compensable time. Thus, an employer is not legally obligated to pay for time voluntarily spent traveling off-site to obtain or eat a meal. It also is not required to extend the 30-minute meal period to accommodate time an employee may spend leaving and returning to his or her work area from off-site before or after a meal. So generally, the principle is under the FLSA, a bona fide meal break is not compensable time when the employee is freed from all duties. So what this says is that, even if the employee can't necessarily leave the employer's premises, so long as they're freed from all duties, employers can still treat that 30-minute meal break as non-compensable. So what the next letter was focused on was pre-shift and post-shift activities. So this letter addressed whether certain pre-shift activities by hospital workers constituted compensable work, and if so, whether rounding an employee's clock-in time to their scheduled shift time start is permissible. So in this scenario, the pre-shift activities included locating work assignments, completing accountability documentation, assigning employees to work locations, and receiving handoff reports regarding patient status from the previous shift workers. So the DOL clarified that some of these pre-shift activities, such as receiving the handoff reports and locating work assignments, qualified for compensable time because they were integral and indispensable to the principal work duties. That's the language that we get from the FLSA, integral and indispensable to the principal work duties. However, it said that waiting in line to clock in or at timekeeping stations is not compensable time if it occurs before the employee's first principal activity of the day or after the last principal activity of the day. So the hospital, this is with respect to the rounding practices, the hospital in this scenario permitted employees to clock in up to 7 minutes before their shift started to avoid tardiness, but it did not pay the employees for that time because it claimed that such time was de minimis. The hospital rounded up to the shift start time, but did not use any other rounding practices. So what the DOL found here was that if employees regularly perform compensable work before their scheduled shift begins, then the employer's rounding practice at the beginning of the day may result in minimum wage or overtime violations because it exclusively benefits the employer. However, if the employees are engaged in non-compensable activities like getting coffee, socializing, checking phones, or storing personal belongings, this time may be considered de minimis and the rounding practice may be acceptable. So we'll go into this a little more in our next webinar, but to the extent that you use rounding practices at your organization, this may be something that you want to pay attention to. So this third opinion letter here was the one that involved the employee in two different roles. This one discussed whether an overtime exempt employee can perform additional work in a secondary non-exempt role at an hourly rate, and if so, what overtime implications might arise. This letter addressed a question from an academic medical center with a nonprofit hospital, which employed non-exempt staff nurses who sometimes worked as nursing professional development specialists, which was the role that was typically classified as exempt. So as we know, the FLSA provides an exemption from overtime and minimum wage for employees working in a bona fide executive, administrative, or professional capacity. The DOL here clarified that if an employee performs work in both exempt and non-exempt roles in the same work week, the employee can be properly classified as exempt if the exempt role remains the employee's primary duty. So when a substantial majority of the employee's time is spent in the exempt role, that generally satisfies the primary duties requirement for an exemption. The DOL, and so in this case, if the primary duty was the exempt work, these nurses would not be entitled to overtime in a work week, even if the combined non-exempt work and exempt work exceeded more than 40 hours a week. The DOL was very clear in this opinion that this is a very highly fact-specific determination. So to the extent that you have employees that potentially could be working in two different roles, this will really depend on the facts of that. The last opinion I'll go over quickly was related to bonus pools. So this one addressed how a quarterly bonus program can remain compliant with the FLSA's overtime pay requirement for non-exempt workers. So for purposes of determining overtime, the FLSA says that the regular rate is the total of all remuneration for employment paid to or on behalf of the employee for the work week divided by the total number of hours worked. So in that total remuneration calculation, non-discretionary bonuses must be included in that regular rate, but discretionary bonuses do not need to be included. So with the bonus pool, some employers compare each employee's total earnings to the total earnings of all the employees in the pool to determine the share of the bonus pool to pay each participating employee. So thus, each employee received a different percentage of the bonus pool. The DOL here clarified this practice is acceptable so long as the earnings for each employee include any required overtime premiums and do not include any amounts previously excluded from that regular rate of pay when determining those overtime premiums. So this is a tricky area of the law. Hopefully, with our webinar next month, we'll be able to clarify some of this. And to the extent you have any specific questions, always feel free to reach out. And
Thanks,
Tara, I
Julie.
think I have one more update.
One more update, and then we'll get to our leave issue for this particular month. So in this particular update, you may have heard us or seen some headlines about the EEOC taking some steps to end EEO1 reporting. But Colorado last month has implemented its own law requiring EEO1 reporting at the state level. And so what that law requires is that private employers with at least 100 workers are going to have to file employee demographic data and file that with the Colorado Secretary of State. So why is that important to you on this particular webinar? One, if you have operations in states other than Nebraska, you should just be knowledgeable that some states may be taking steps to require this type of demographic data to be submitted at the state level, whereas before it was handled at the federal level with the EEOC. And as you might expect, there's still a number of open questions, even on this Colorado law. For example, the statute doesn't specify whether employers must report Colorado-only employees, Colorado establishments, or enterprise-wide workforce data. And so to the extent we start seeing these types of state laws creep up around Nebraska, sometimes, as you know, that those then can make their way into Nebraska. So just be knowledgeable that even if at the federal level they do end all EEO1 reporting, where you have to include that demographic data, there is a likelihood that states will require that type of demographic data to be filed at the state level, and so that may be implicated. All right, Julie, now we're ready.
Okay,
Flip over to the next slide.
Move on to our topic for this month. Our goal for this webinar today is to help you with a couple things. First of all, it's to recognize when a leave or other accommodation obligation may be triggered, to understand the basics of the ADA, the FMLA, and the PWFA as far as recent developments under these laws. To help you, we'll talk through how to navigate some of the overlapping requirements of these laws, because as many of you know, many of these situations that come up trigger several laws or a couple laws. It's not usually just a clean cut issue. So we'll help you navigate some of the overlapping requirements and help you reduce legal risks through appropriate documentation and communication.
All right, so today's workplace reality. If you are thinking to yourself, or when you saw this particular topic for this webinar come up and you thought, gosh, I feel like we have had an increase in the number of leave requests that our organization is handling. Or maybe you thought to yourself, it seems as if there's been a growing number of mental health accommodation requests or requests for remote or hybrid work. Well, we're here to tell you that based on a study from 2025, over half of employers reported an increase in the number of leave requests that their organization had to handle in 2025. And 2/3 of employers that were surveyed indicated that they saw an increase in the leave requests jump up by over 20%. In that particular survey that we looked at, one of the places where there was a really significant hike was on requests for bereavement leave. So, where does that leave us? One, if you're feeling like you are dealing with more leave requests, you would be in good company. Again, over half of employers are indicating that they are having to deal with more leave requests than they have had to in the past. Two, there's been a number of recent litigation matters filed by the EEOC um, that we're dealing with or are still dealing with leave requests. So, in one of them, there is an organization called Geisinger Health, and they settled with the EEOC, had to pay $450,000 for a disability discrimination claim. The policies at issue in that particular lawsuit had limited job protective leave and required employees who were returning from leave to compete to get their job back. Ultimately, that employer settled with the EEOC. But again, it's timely. Just a couple of months ago, back in April and then also in March, the EEOC sued two different employers. One was Butterball. In that particular instance, an employee had cancer and was told to work through a third-party benefits administrator for leave. Again, this is what the EEOC has alleged. The employee was never granted leave, and then the employee was fired after enough absences due to cancer-related medical appointments. So again, that lawsuit's still at its infancy, but shows you that this is an issue that the EEOC is exploring. Another EEOC lawsuit, they filed a lawsuit against Kroger in March of 2026. And this particular lawsuit, what we know is the employee had been using a walker for a long time, but then was denied that accommodation by new management. New management instead told the employee that that employee needed to seek leave instead. When the request for leave was denied, that employee was then fired. So again, not only do some recent surveys suggest to us that this is an issue worth talking about, we know from calls from clients it's an issue that we routinely are advising on, and then we know that this is something that the EEOC is taking a closer look at as well and has filed lawsuits this year regarding those types of issues. So when we think about the type of laws that may be potentially triggered by a leave request, as Julie mentioned, it's often not clear cut. We're going to have to ask ourselves which of the various laws may be implicated. I wish, I'm sure you do as well, that each employee would come in and say, I've got this issue, and so I'm seeking leave under the ADA, FMLA, and Pregnant Workers Fairness Act. And then that would tell you exactly where you needed to go to decide how to handle that particular request. But it's often never, ever comes up like that. It's just someone saying, I've got this issue and I need time off of work. Or perhaps the employee just stopped showing up for work and you later find out that they've got some medical condition or a need for accommodation. On this particular slide, we just included the different laws that could be triggered by a request. And again, oftentimes it's more than one of these. So the Americans with Disabilities Act, Family and Medical Leave Act, Pregnant Workers Fairness Act, Workers' Compensation Law, USERRA, which is military leave. And then obviously there are other state and local leave laws that have to be discussed as well. So that just kind of gives you an overview of the type of laws that potentially can be triggered by a single leave request. To kick off the webinar, we're going to introduce you to Sarah as a case study. And we're going to give you a few facts about Sarah, and then we'll kind of delve into some of the legal requirements. So here in this case, Sarah is a customer service manager. Assume that Sarah is pregnant, has been diagnosed with anxiety, and requests remote work. In addition, you know that she's going to need time off for medical appointments. So our question to you that at this point is going to be rhetorical is which of those laws on that previous slide may be implicated. We'll revisit Sarah after we go through some of the basics under some of these laws in the next few slides.
So the first law here is the FMLA, the Family and Medical Leave Act. This is the U.S. federal law that allows employees to take unpaid job protected leave for certain family and medical reasons. It also requires employers to continue the employee's group health insurance under the same terms as if they were still working. So, what are the basics of the FMLA? First, who is eligible? To qualify for FMLA leave, you generally must work for a covered employer. So that means private employers with 50 or more employees within a 75-mile radius. It also includes most public agencies and public schools, regardless of size. You also must have worked for, if you do work for a covered employer, you must have worked for that employer for at least 12 months. These months aren't necessarily consecutive. Are not necessarily required to be consecutive. However, you have to have worked at least 1,250 hours during the 12 months before the leave begins. So, for what types of reasons can you request FMLA leave? So, eligible employees may take up to 12 work weeks of leave in a 12-month period for reasons such as the birth of a child or bonding with a newborn. It's available for adoption or foster care placement. It is available for caring for a spouse, child, or parent with a serious health condition. FMLA leave can be taken for the employee's own serious health condition that makes them unable to perform their job. There are also certain qualifying needs related to family members' military service. Employees may be eligible for up to 26 work weeks of leave in a single 12-month period to care for a covered service member with a serious injury or illness. So FMLA leave is unpaid. However, employers may require or they may allow employees to choose to use accrued paid vacation, sick leave, or other paid leave during the FMLA leave, depending on the employer's policy and applicable law. Some states have separate paid family and medical leave programs that can provide wage replacement, often running concurrently with this FMLA leave. So FMLA leave provides job protection. So when you return from FMLA leave, you generally have the right to return to the same job or be restored to an equivalent job with equivalent pay, benefits, and other employment terms. If you receive employer-sponsored health insurance, your employer generally must maintain your coverage during FMLA leave under the same conditions as if you had continued working. There's some notice and certification requirements under the FMLA. If your need for leave is foreseeable, such as a planned surgery or the birth of a child, you should generally provide 30 days notice if possible. And employers in certain circumstances can request medical certification supporting the need for leave. So primary responsibilities of the employer. Covered employers must inform employees of their FMLA rights. There's an FMLA poster that should be posted in break areas. Employers should make sure that they are designating qualifying leave as FMLA leave. And as with everything else, refrain from interfering with or retaliating against employees for exercising their rights under the FMLA. So what are some common mistakes that we see here? So some of the most common mistakes employers make here is failing to recognize leave requests. So if an employee says, I'm having anxiety, I'm having trouble completing my work, perhaps they're struggling with some depression and they're having trouble concentrating. A lot of times comments made in this regard can be overlooked. So failing to recognize requests for leave or requests for accommodation, as we'll discuss later, is a big mistake employers often make. Another mistake is delaying eligibility notices, so not acting promptly when FMLA leave is requested or when the need arises. Another common mistake is just inconsistent leave administration, and then counting protected absences against employees.
Julie, I might even add one more because it's come up in some of the things that I have dealt with over the past month or so, and that is employers not recognizing when an employee is not eligible for FMLA leave. So Julie covered this on the prior slide, but for an employee to be eligible for this job protective FMLA leave, they have to have worked for their employer for 12 months and at least worked 1,250 hours during that time period, and be working at a work site that has 50 or more employees within a 75-mile radius. So if you are offering FMLA leave to an employee who's only been with you for 3 months, recognize you are doing that out of the goodness of your heart. It is not required under the FMLA because that employee is not an eligible employee. They haven't worked long enough for you to be entitled to this unpaid job protected leave. Another thing that Julie and I have seen, and Julie does a lot of work with our employee handbooks, but sometimes employers will have FMLA policies in their employee handbook, but they are not they don't have a work site that has 50 or more employees at it. So there's no way that any of their employees would ever be eligible for FMLA. Be careful if you have an FMLA policy where you tell employees that here is this leave bucket that's available to them. You're going to likely have to honor that if it's a provided benefit in your employee handbook, even if the law wouldn't otherwise require you to provide it. So make sure that those employee handbooks that you've got only have the type of benefits in them that you need to have. If you are a smaller employer under 50 employees, you do not need to offer FMLA. And because of all of the required notices and how sometimes difficult it can be to comply with the FMLA, we typically advise employers, if you do not have to provide this benefit, you should not tell employees that you're going to or voluntarily provide it. Another kind of maybe challenge or friction point when it comes to FMLA leave are intermittent leave challenges. This is probably one of the most difficult areas for employers to navigate, is when they have an employee who's eligible for FMLA leave and their medical provider says that the need that they have that qualifies for FMLA leave is intermittent, where they may need to be off of work. Maybe it's on a regular schedule, but oftentimes these intermittent leave documentations from providers, it really is just intermittent, or it could be just when certain things flare up, the employee may have a need to be out of work. Where we see this come up the most often is when an employee perhaps is requesting to use intermittent leave repeatedly on Mondays or Fridays. Perhaps you're questioning whether they're just trying to elongate their weekend. Sometimes it can surface in terms of frequent tardiness or last minute call-ins. And so in terms of best practices for intermittent leave challenges, we recommend that you have a consistent attendance tracking system. You have accurate tracking, and you do some form of certification review with that employee so that they are signing off or recognizing when it is that you're counting their leave as FMLA leave. Obviously, when an employee has a need for intermittent FMLA leave, it's going to take much longer than 12 weeks for them to exhaust that leave benefit that's available to them.
So we'll quickly go over the basics of the next law here, the ADA. So as we know, the ADA is the federal law that prohibits discrimination against qualified individuals with disabilities in areas including employment, government services, public accommodations, transportation, and telecommunications. So what are the basics? So who is protected? The ADA generally protects people who have a physical or mental impairment that substantially limits one or more major life activities, individuals that have a record of such impairment, and individuals who are regarded as having such an impairment. Examples of major life activities include walking, seeing, hearing, learning, concentrating, communicating, and working. So Title I of the ADA is what governs discrimination in employment. The ADA applies to employers with 15 or more employees. A qualified employer applicant with a disability is protected from discrimination in all areas of employment, including hiring, promotions, pay, training, benefits, discipline, termination, etc. Under the ADA, employers must provide reasonable accommodations to qualified employees or applicants with disabilities unless doing so would create an undue hardship. So examples of accommodations are anything from modified work schedules, changes to workplace policies, specialized equipment, making facilities accessible, reassignment to a vacant position, or leave in some circumstances. So under the ADA, if an employee requires an accommodation, the employer is obligated to engage in what is called the interactive process. So this is when an employee requests an accommodation or the need is otherwise apparent to the employer. The employer and employee are generally expected to engage in an interactive process to determine an effective accommodation. So this process can be very informal, but often involves discussing the employee's limitations, identifying possible accommodations. It can involve requesting medical documentation if the disability or the need for accommodation is not obvious. And then it includes an evaluation of whether an accommodation would be effective or whether it would pose an undue hardship. So the ADA many other laws are triggered sometimes when an employee makes an ADA request. Particularly with the FMLA, the laws are different, but they can overlap. So the FMLA provides eligible employees with job protected leave for certain family and medical reasons. Meanwhile, the ADA focuses on preventing disability discrimination and may require reasonable accommodations, which can sometimes include leave, such as FMLA leave, modified schedules, workplace adjustments, etc. So an employee may be protected by one law, both laws, or neither, depending on the circumstances. So what is the interactive process? We'll go into this a little bit more depth here. So the first obligation is that as soon as an ADA request becomes apparent, the employer needs to promptly engage in this process. So promptly meet with this employee, communicate with this employee, and figure out what their limitations are. So the first step really is to engage with the employee. The second step is to gather information. So we may go over this later in a different slide, but there are some rules in the ADA regarding how much information an employer can gather. So under the ADA, an employer cannot require a doctor's note simply because an employee has a disability. However, an employer may request reasonable medical documentation in certain circumstances. So generally, a doctor's note or other medical documentation may be appropriate when the request for reasonable accommodation or the disability is not obvious or already known to the employer. Medical documentation can be needed if the employer needs help determining whether the employee has an ADA covered disability, how the disability affects the employee's ability to do their job, and why their accommodation is needed. Documentation should be limited to information relevant to the accommodation request. Employers generally should not request complete medical records or unrelated medical information. Doctor's notes are usually not appropriate to request when an employer generally, when the disability or the need for accommodation is obvious. For example, if an employee has a wheelchair, the employer already has sufficient information to support the accommodation. So generally, if it's obvious, then it's not going to make sense to make the employer require a doctor's note or any kind of certification. So a lot of employers ask, what can we ask during this process? Generally, the employer can ask for documentation that, one, confirms that the employee has a qualifying impairment, describes any work-related limitations, explain why the accommodation is needed, and so long as it doesn't request a broad medical history or irrelevant information. So once kind of the information is gathered, the next step is to explore options. So there is a website called, it's JAN, I can't remember what it stands for now, Tara, but that's a great resource for employers that provides all types of workplace accommodations based on what the employer's particular impairment is. But it's good at this point to document what accommodations were considered, and then kind of document the reasons why some were accepted or others weren't. So then kind of the last step of this process is to assess the effectiveness. So in this area, really look at what are the essential functions of this employee's position. If you have a job description, that's always very helpful here. Is this accommodation effectively allowing this employee to perform the essential functions? And if not, maybe worth re-engaging in this process. So that's an overview.
Yeah, Julie, great resource. If you are taking notes, go ahead and write down JAN. It stands for Job Accommodation Network. The website. It's a free source to work through different workplace accommodations issues, and there's oftentimes a lot of suggestions on how to handle certain types of medical conditions. The website is askjan.org. So if that is a resource that you can find helpful, then you have that available to you as well. ADA accommodation process. Julie did a wonderful job of explaining what that process looks like, some common accommodation request examples, or at least ones that we see most frequently, are requests for remote work, schedule modifications, perhaps a leave of absence, additional breaks, reassignment, modified duties. We're going to take at least the remote work one and kind of dissect that one a little bit. Sometimes employees may have a situation, and what is recommended or what they're asking to be accommodated is their ability to work remotely. Questions that you should be considering if you have an employee that requests to work remotely as an accommodation is: one, can essential functions be performed remotely? Two, to the extent this employee or others have worked remotely before, was previous remote work successful? And what operational challenges exist or existed in the past when you allowed that? So again, this is a fact-dependent inquiry. We cannot on this webinar tell you all of the times in which remote work would be considered a reasonable accommodation, juxtaposed against those that may present an undue hardship to the organization. But these are things that you're going to want to look for. Can the essential functions of that job be performed remotely? Place to look for those essential functions or what's in the job description. What is it that this employee does most regularly? Can that be done remotely as you are navigating that particular issue? Julie's going to cover another kind of more common issue, and that's mental health accommodations.
Yeah, so this is something that we're seeing with increasing frequency. So mental health accommodations can qualify as disabilities under the ADA if they substantially limit one or more major life activities, like we discussed previously. So some common mental health conditions that could potentially qualify include major depressive disorder, generalized anxiety disorder. There's been more requests for accommodation due to post-traumatic stress, bipolar disorder, obsessive compulsive disorder, and things as serious as schizophrenia. So the diagnosis alone does not automatically qualify someone for protection. The key question is, does this condition substantially limit major life activities of this employee? So the same accommodation interactive process applies for mental health conditions as it does physical conditions. There's certain things under the ADA that it says that the employer is not required to do when it is considering whether or not it can accommodate an employee for a mental health condition or otherwise. It says that the employer is not required to eliminate essential job functions. The employer is not required to lower production or performance standards that apply to other employees. And employers are also not required to tolerate misconduct or safety violations because of a person's disability. So still the interactive process is the same. It's just a little trickier. And I know in the past, I think we've done an entire webinar on recognizing invisible disabilities. I think that was the title of it, probably from a year or so ago. So that'd be a good resource for employers who are dealing with this.
Let's go through a scenario that may be one that you have been confronted with or will be confronted with. So here, let's assume you've got an employee that comes in and says, I'm struggling with anxiety and need some flexibility. Here's perhaps a way that you can work through this to determine for yourself what needs to happen. One, is this an accommodation request? Julie, what do you think?
Tara, I would ask my first question would be, because of this anxiety, are you having trouble performing the essential functions of your job? And what functions of your job is the anxiety interfering with?
So I think maybe then easy way to think about this is if your employer or your HR, you're going to ask a few more questions, aren't you? To kind of figure out what it is that the issue is and how it's impacting their position. I think you covered this, Julie, but let's assume that employee says, here are the things that I'm struggling with at work, and I need to be relieved of all of these responsibilities. Can the employer ask any medical information from this employee to substantiate this at this point in time?
I think so, Tara. I think if it's not clear, and with mental health conditions like anxiety, it's not always clear exactly how they are impaired or what major life activities are being impacted. I think in that situation, you could request an employee to get a doctor's note that elucidated what the extent of the impairment is.
Great. Well, let's kind of shift to our next law that we wanted to cover, which is the Pregnant Workers Fairness Act. Um, Hopefully, a lot of you know this already. This went into effect in June of 2023. In April of 2024, the EEOC released some regulations that discussed how this law is to work. But the Pregnant Workers Fairness Act requires covered employers. So you're a covered employer if you have 15 or more employees. You have to provide reasonable accommodation to qualified employees or applicants who have known limitations related to, affected by, or arising out of pregnancy, childbirth, or related medical conditions, unless that accommodation would present an undue hardship. So there are a number of things that the PWFA prohibits. For example, covered employers cannot fail to make a reasonable accommodation for a known limitation of an employee unless the accommodation would cause an undue hardship. You cannot require an employee to accept an accommodation other than a reasonable accommodation arrived at through the interactive process with that employee. So again, this is a place where I'd say employers have always accommodated employees who are pregnant in certain capacities, but now this law gives us a lot more teeth to what employers have to do in these circumstances in order to comply. So we don't have a ton of time, but maybe we can go through a couple of examples of accommodation requests that come up under the PWFA. Julie, do you have a couple of
Sure,
those?
yeah. Yeah, so just like the ADA, I mean, what could be considered a reasonable accommodation is essentially endless. What I will point out on this slide is under the PWFA, there are 4 accommodations that the EEOC has called what they've deemed predictable assessments. And so what this means is that in virtually all cases, these accommodations will be considered reasonable and not impose an undue hardship when requested by a pregnant employee. So the 4 predictable assessments, as they've named them, include allowing the employee to carry or keep water nearby and drink as needed, allowing the employee additional restroom breaks as needed, allowing the employee whose job requires standing to sit or whose job requires sitting to stand as needed, and allowing breaks to eat or drink as needed. So these accommodations are considered so simple and common that in the vast majority of situations, they should not create an undue hardship for the employer. The EOC emphasizes that the analysis for these requests should be particularly simple and straightforward. So these almost always should be granted. If there is anything more in depth or intensive, we'd go through kind of a similar ADA analysis. However, just note that under the PWFA, the person does not have to show that this pregnancy or their pregnancy related condition amounts to a disability. That's not required. You don't have to show that it substantially limits any major life activities. It's just, are they pregnant or is it a pregnancy related medical condition? And then that automatically triggers the requirement to engage in an interactive process and find a reasonable accommodation.
And keep in mind too, under the Pregnant Workers Fairness Act, it specifically states that an employee may be relieved of the essential functions of their position as a reasonable accommodation because the request or that accommodation is temporary, meaning it won't last forever. So whereas under the ADA, we do not have to accommodate someone by relieving them of an essential function of their position. Under the Pregnant Workers Fairness Act, you will have to accommodate an employee who may need to be relieved of an essential function of their position because the duration of that leave request is going to be finite. And so a little difference between the ADA and the PWFA as it relates to essential functions and how to handle requests to be relieved of certain responsibilities that may be considered an essential function of the position. Julie, we have got, let's see, it looks like 4 minutes left. What are some of the things that you want to touch on before we close out this webinar? Perhaps maybe we can touch a little bit on the undue hardship analysis, just to make sure that we've apprised all of our listeners here as to the fact-dependent inquiry that you have to make to in order to substantiate that a request does not have to be accommodated because it presents an undue hardship. Sorry to jump ahead there, but I think that might be helpful as we go through closing out.
Yeah, so when assessing the undue hardship, this comes up under the ADA and to a lesser extent under the PWFA. But generally, when evaluating an undue hardship, or whether it would create a significant difficulty or expense. And so relevant factors here include the length of the requested leave. This is with the length, if it's a leave request, the length of the requested leave, the frequency of the leave if it's intermittent, the impact on the business operations. Undue hardship also focuses on the employer's size and resources, whether temporary coverage is available, and the effect on other workers. So it's very fact specific depending on the size of your organization and the resources that you have available. Tara, any other big
I just
points?
thought maybe one other thing that we'd kind of cover real quick before we close out is just make sure that your supervisors, your managers know how to identify accommodation requests, when they need to transition those conversations over to HR, and perhaps maybe most significantly, train your managers on what not to say. So red flags that you don't want your managers to say when there may be an accommodation request made are things like, we don't allow that, or everyone has stress, deal with it, or you've already taken too much leave. Those are the types of things that can sometimes and oftentimes do get employers into trouble. So make sure that you've trained your managers on how to identify accommodation requests, when to turn it over to HR, and probably most specifically, what not to say.
And the other thing I'll add here with respect to your handbooks is that you want to make sure you're avoiding any policies that draw a hard line, such as a policy that says no more leave beyond the 12 weeks of FMLA will be granted in any circumstance. Or if there's another policy that essentially eliminates the employer's responsibility to engage in the interactive process, we know it's a very fact-specific scenario, so we want to avoid any hardline policies that say we won't accommodate, beyond a certain point, or we won't accommodate this in any circumstance. Avoid policies like that.
Thank you, Julie, and thank you everyone for participating on our webinar here today. Our next First Friday webinar series will be on Friday, August 7th. Julie already gave you a little foreshadowing as to what we're going to cover, which are wage and hour issues. If you have any questions whatsoever on any of the matters that we discussed here today, or leave requests in general, or I suppose any workplace matters in general, feel free to reach out to Mark, Julie, or myself. We would be happy to assist you. With that, we will let you go. Wish you all a very happy 4th of July, and we will see you all soon. Thank you.